All rise.
You may be seated. Just for the record, before we get started, I did go into both jury rooms today to deliver mass. We did not have any discussion about the case, but I did feel it necessary to get them the mass as soon as possible. Is that correct, ladies and gentlemen? Yes. Okay. We're going to continue on with the testimony. Ms. Grubb, doctor, you're still under oath.
Yes, Your Honor.
Good morning to the court. Good morning, Dr. Schweiger, ladies and gentlemen of the jury, defense team, colleagues. Before we turn our attention back to Mrs. Penix, I would like to turn my attention, our attention, back to the Bonnie Austin matter. I believe I erred last night and did not ask a series of questions about Dr. Husel's intent with respect to the Bonnie Austin matter. Dr. Schweiger, could you just refresh us all briefly as far as which one of the alleged victims Mrs. Austin is?
Yes, Ms. Austin was the 64-year-old female who suffered an out-of-hospital arrest, received CPR, and then via EMS, the Lucas device, transferred to the emergency room, was found to have a pneumothorax, which is a deflated lung, for which she had a chest tube placed, and that then returned her spontaneous circulation and was then admitted to the ICU.
Can you just do a quick refresh?
Okay.
Well, Your Honor, that's what he's doing.
Go ahead.
And then was admitted to the ICU, intubated for continued life support.
Thank you. What actions or lack of actions by Dr. Husel speak to his intent in the matter of Bonnie Austin?
Yes, in terms of lack of actions, the lack of seeking additional consultation on Mrs. Austin's case, given that she had a known reason for her cardiac arrest, that being the deflated lung. Number two, the lack of providing adequate time or duration to assess her underlying condition to see whether the placement of the chest tube would reverse the course of her disease and thus allow her cardiopulmonary system to declare itself. Number three, the lack of allowing adequate time for the patient's neurological condition to declare itself, particularly given that the patient had adequate capnography and production of CO2 during transfer and the CPR en route to the hospital. Also, the failure to obtain palliative care consultation to seek a consensus view as to what Ms. Austin's wishes would be for end-of-life discussion. And then, again, in terms of the intent, the excessive dose of the opioid administered at the time of the palliative care, which would essentially guarantee that she would hypoventilate and result in a sudden death. All would be signs of the intent of Dr. Husel in the care of Ms. Austin.
Thank you. Okay, moving back now to Melissa Penix. I believe that the witnesses previously identified State's Exhibit 32P as his review of Ms. Penix. I'm going to page 3, Dr. Schweiger. The bottom of page 3, oops, turn this puppy on.
Takes a second to focus on the autofocus unless you took it off.
I'm sorry.
Then again. Ms. Schaefer, you want to go out there and see what you can do?
Oh, there we go.
She must have turned it off.
There we go. I'm going to direct your attention to the bottom of page 3, which includes a list of home medications. Do you see that?
I do see that, yes, ma'am.
And then at the top of page 4, that list of home medications continues.
It does, yes.
Okay. Were those secured from the medical record in this case?
They were, yes, ma'am.
I'm going to show part of the history and physical in this case, which is page 11 of the medical record, which details some current home medications, starting with morphine, BID, which I believe is twice a day. Is that correct?
Yes, BID stands for twice a day.
Okay. Did that did that home medication appear on your list in your review?
It did not, no, ma'am.
Okay. I'm now going to show you page 14 and 15 from the medical record. This is 14, which is consultation. There's a list of home medications in the middle of this consultation. Do you see that?
Yes, ma'am, I do see that.
How does that list compare with your list in the report?
This list essentially compares favorably to the list that I had in my report. It is reflected in the list that was not only in the report but also in the discharge summary.
Thank you. Do you want to see any of these, Diane? Okay. Let me just make sure I've got them. 16. I'm now going to place page 35 from the medical record. What does that list purport to be?
So this list purports to be the inpatient medications that were prescribed for Ms. Penix during her hospitalization at Mount Carmel West.
Okay, thank you. And does it include an opiate?
Yes, this list does include a form of morphine known as continuous release morphine, and otherwise known as MS-Contin.
And what's the dosage?
It is listed as being 15 milligrams per tablet, and that the patient would be allowed to have one tablet every 12 hours as requested.
Thank you. And how does that compare with the list of meds at admission?
So she was not on the continuous release form of morphine at the time of admission. It was basically showing the regular release form. So she was on a higher dose of morphine on admission than she was on the MS-Contin, that being 50 milligrams versus the 15 milligrams that was listed on admission,
Okay,
or with the admission orders.
okay. And then again, the consultation with the home medication, is morphine even listed?
It is not, no ma'am.
Okay. Dr. Schweiger, I'm going to approach with the medical administration record for Mrs. Penix, which appears at pages 708 to 748 in the medical record. I'd like to turn your attention at this point to the infusion section. Now I'm starting to see.
Okay, I'm at the first page of the continuous infusion record.
Okay, can you review the continuous infusion record, please? And I keep on losing my pen. There's one right there. Got it.
Okay, I'm done.
Thank you. What did you find in the continuous infusion record? I'll leave this one.
Yeah. So what I find is that there starts with her maintenance fluids of normal saline. There's also an indication that the patient received a vasopressor by the name of Levofed. Then there was the start of a fentanyl infusion that was listed at 25 micrograms per hour. In addition to that, a second vasopressor was started that's known as vasopressin. Thereafter, there was an indication on November 20th at 9:22 that the rate of the fentanyl infusion had been increased to 100 mics per hour. And then there was a dose adjustment on the Levofed. There was also an indication at 10:08 in the evening that a Versed infusion was started at 1 milligram per hour. And then thereafter, 40 minutes later, it appears that the Versed infusion has been reduced to 0 milliliters per hour, and that the vasopressin has been reduced to 0 milliliters per hour. The Levofed has been turned off. The fentanyl infusion has been turned off.
Thank you. What do you deduce from the medications being terminated?
Certainly at that point, Ms. Penix required the infusion of vasopressors to support her heart and blood pressure. So by terminating the Levophed and the vasopressin, it would essentially guarantee her blood pressure dropping and her cardiac output falling, which would accelerate her death. And then also the termination of the infusions appeared to correlate with the time that she then received bolus doses of the fentanyl and the Versed.
Thank you. Please turn your attention to the afternoon hours of 11:20 in the non-infusion portion of the MAR.
Okay, I've looked at the afternoon administration.
And evening also.
And evening.
Okay. Can you tell us what orders were placed and administered under the prescriptive authority of the defendant, William Husel?
The first order that I see prescribed by the defendant, Dr. Husel, occurred on November 20th at 8:16 p.m., and it was an order for midazolam, which is Versed, and 2 milligrams were ordered by intravenous push. Then the next entry that I find in the chart occurred at 9:15 in the evening, and that was for an injection of steroid, hydrocortisone, where 100 milligrams were ordered to be administered to Ms. Penix by intravenous push, and that was confirmed to have been given. A minute later, at 9:06, the patient was prescribed to receive 1 amp of sodium bicarbonate by intravenous infusion, and that too was confirmed by Nurse Black, who administered the medication.
Doctor, in the interest of economy here, perhaps we can move past the non-paralytic and non-narcotic medications into those other classes, the paralytics and the narcotic.
Yes, and I was going to get there. The next entry is the paralytic.
Thank you. What time is that?
So at 9:10 p.m., 4 minutes after the administration of bicarbonate, it is indicated that the patient was ordered 10 milligrams of vecuronium to be administered by IV push, and that was from the defendant, Dr. Husel, and confirmed to have been given by Nurse Black. Then at 10 p.m., there was an order for Nimbex, which is a second paralytic, and that was ordered to be given at 7 milligrams, and that too was confirmed to have been given by Nurse Black at 10:01 p.m. And then approximately 48 minutes after that order for the Nimbex was an order for fentanyl, 2,000 micrograms, to be administered, and that was confirmed a minute later at 10:49 by Nurse Black. And then at the minute after that was an order for Versed, 10 milligrams, which was confirmed at the same time at 10:49 by Nurse Black.
Thank you. Doctor, do you believe, or what is your opinion with respect to the survivability of, or salvageability of Melissa Penix's condition at the time prior to her palliative extubation?
On November 20th, Ms. Penix's condition was definitely not terminal, nor was further medical care futile. As mentioned, she was brought in with a treatable underlying disease and had been supported up through that time. Her body had not declared itself as definitively progressing to a trajectory of death. So she still warranted continued medical care and support in the ICU.
What laboratory values or other testing informs this decision?
What testing informs the decision was both her vital signs, the laboratory testing that was done, the chest x-ray that had shown pathology that warranted treatment, for which she was receiving antibiotic treatment to try to correct any underlying infection or pneumonia.
Are there any particular tests that you want to address?
So of import was the arterial blood gas, which at the time it was taken in the late morning on November 20th at approximately 11:48, still showed that she had a reasonably normal acid-base balance, that her arterial oxygenation was actually quite good. It was actually with the supplemental oxygen above what would be considered an acceptable range. And then her ventilatory status, her ability to expel carbon dioxide, still remained excellent. We also see on the next page that her hemoglobin, although slightly low, was not at a critical value. It was 8.6. And her serum bicarbonate at 15.6 certainly showed that there was survivability.
Thank you. In your opinion, was a palliative extubation appropriate for this lady at this time?
No, in my professional opinion, a palliative extubation should not have been considered or advocated for, given that she still had multiple medical conditions that were receiving the appropriate care, and that she needed ample time for the antibiotics, the steroid administration, and the support of ventilatory and cardiac support to work and allow her body to recover.
Thank you. Was the dosage of 2,000 micrograms of fentanyl along with 10 milligrams of Versed an appropriate dose for this lady in the course of removing ventilation?
No, in my professional opinion, a dose of 2,000 micrograms of fentanyl when combined with 10 milligrams of morphine would be dramatically in excess of what any reasonable physician would administer to an 82-year-old patient with these underlying diseases, and would be essentially a guarantee that the patient would stop breathing within 10 minutes and suffer a respiratory arrest from apnea, which would lead within 100% assuredness to the patient's death.
In your opinion, does the possible ingestion of her possible 50 mics twice a day, or milligrams of morphine twice a day, and or 15 milligrams of morphine in the hospital, along with any other opioids that she may have received, inform your decision that 2,000 micrograms is inappropriate?
Absolutely not. Even with the entry on her history and physical that she had been prescribed morphine at 50 milligrams at home, and then that it had been converted to the MS Cotton at 15 milligrams, that does not alter my opinion that a dose of 2,000 micrograms of fentanyl, when combined with the 10 milligrams of Versed, would be 100% fatal for the patient if administered, given her advanced age, the underlying disease states that she had. There's no evidence that she had significant tolerance to these opioids, but even if she had, the administration of an extremely potent medication such as fentanyl at that excessive dose, when combined with the Versed, would immediately bind to her brainstem, terminating her ability to breathe. So upon extubation, death would be assured at 100% within minutes.
In your opinion, and to a reasonable scientific certainty, was Ms. Penix still suffering the effects of paralytics at extubation?
Yes, given the fact that Ms. Penix had received not only one, but two muscle relaxants, which are paralytics, prior to the terminal extubation, more likely than not, within a reasonable degree of medical certainty, there was still residual muscle paralysis impacting her ability to breathe. So that would have accelerated the likelihood of death in this case. And again, without either giving an ample time, such as 3 hours or more, for her body to clear these muscle relaxants, or for them to have been assessed with a nerve stimulator to make sure there was no residual impact, and then to reverse them with an antidote, they too would contribute to a 100% certainty of death shortly after the patient's breathing tube would be removed. So they would hasten the death, particularly in combination with the 2,000 micrograms of fentanyl and the 10 of Versed.
Does the medical record reveal any attempt to test for the lingering effects of the paralytics?
No, I carefully reviewed the entire record of Ms. Penix after seeing that she had been administered both Nimbex and Vecuronium to determine whether any of the physicians or nurses made an attempt to assess the impact of the muscle relaxant on her body, particularly given that the palliative extubation occurred within an hour of the administration of these medications, and their residual effects would more likely than not still be on board. And I did not uncover any attempt to either measure the impact objectively on her body with the nerve stimulator or to reverse those medications pharmacologically.
You refer to a nerve stimulator. What is that procedure?
So a nerve stimulator is available throughout various areas of the hospital, including the operating room, the emergency room, and the intensive care units. It's a very simple device. It attaches 2 electrodes to the distal part of the arm over the nerve, and then there has cables that attach to the box. It sends 4 stimuluses electrically to the nerve, which, if the patient is not relaxed, will then cause the thumb to approach the 5th finger. So you'll see 1, 2, 3, 4 movements. If there is full paralysis, obviously there'd be no motion of the thumb whatsoever. With partial paralysis, you'll see various degrees of movement. But that's the objective way to determine whether or not there is still an impact of those muscle relaxants on the patient's body, particularly since, again, the elderly are slow to metabolize these medications, and then if you add 2 of the medications on board, they will enhance their effect. So you have to make sure that those are tested for before even considering the possibility of removing a breathing tube.
Is there a name for that piece of equipment or the testing?
Yes, the piece of equipment is known as a nerve stimulator, and the testing is called train of 4 testing or nerve stimulation.
Thank you. In your opinion, would a reasonable and prudent physician trained in anesthesia and critical care know the effect of 2 paralytics along with 2,000 micrograms of fentanyl and 10 milligrams of Versed?
Yes, in my professional opinion, any physician trained in anesthesiology as well as in critical care would know the pharmacologic impact of administering 2 paralytic agents to a patient, particularly in combination with 2,000 micrograms of fentanyl and 10 milligrams of Versed. In fact, in any case in the operating room in which nerve paralytics are administered, we always measure the function with a nerve stimulator. So that's part of not only the routine education of the anesthesiologist, but also in terms of the daily practice. And similarly, when those medications are used in the ICU, nerve stimulation is mandatory to determine the depth of paralysis and neuromuscular blockade.
Thank you. Doctor, in your professional opinion, was there any legitimate medical reason for these doses of medication?
No, in my professional opinion, there was no medical indication for the patient to receive these medications nor at these dosages, and particularly given that the paralytic agents are a high alert medication that have known danger to patients in these type of situations. They must be tested for and they must be reversed prior to any discussion about removing a breathing tube or allowing a patient to move to end of life, because they would be a guarantee 100% of death once the breathing tube is taken out. And then if they're combined with excessive doses of fentanyl, which would further reduce the patient's ability to breathe, and Versed, they must be considered in the determination of whether one could proceed safely to a terminal extubation.
Are the 2 paralytics that you mentioned used routinely in an ICU in an intubated patient?
Yes, certainly both Nimbex and Vecuronium are common medications for which a critical care physician would be familiar in patients who have been intubated and placed on mechanical ventilation. I would add that routinely we do not use both together because they're of different categories within that family of nerve blockers. We would primarily use one or the other and then use the appropriate twitch monitor or nerve stimulation to determine the depth of blockade.
What purpose could this level of dosing serve?
In my professional opinion, the purpose of this dosing would be to completely block the patient's ability to breathe on her own, which in the intubated patient would allow the ventilator to completely 100% control the patient's breathing, because the patient's muscles, both in terms of the chest and the diaphragm, would be unable to contract. So you would completely make the patient dependent on the ventilator. If, however, you were going to then decide for some reason to remove the breathing tube and the ventilator, there would be absolutely no medical justification, because it would guarantee that the patient could not breathe and would rapidly die from asphyxiation, from lack of oxygen, and an inability to excrete carbon dioxide.
Thank you. In your opinion, did the dosing of 2,000 micrograms of fentanyl along with 10 milligrams of Versed hasten and or cause Mrs. Penix's death?
Yes, in my professional opinion, within a reasonable degree of medical certainty, the administration of 2,000 micrograms of fentanyl, when combined with the Versed dosing, did accelerate hasten and absolutely guarantee Mrs. Penix's death because she would be completely unable to trigger any form of spontaneous respirations, and death could be guaranteed in less than 10 minutes after the administration of those medications.
In your opinion, does the doctrine of double effect have application in this case?
In this case, absolutely, the doctrine of double effect does not apply. In my 30-year career, I've never administered 2,000 micrograms of fentanyl, nor in combination with the midazolam. It's so out of proportion and lacks any attempt at moderation of dosing in this case that one could not justify that doctrine. Similarly, the combined administration of 2 nerve paralytics would guarantee death. So again, it would violate the law of double effect.
What actions or lack of action by Dr. Husel speak to his intent in this matter?
So in this particular case, the decision to provide not 1 but 2 nerve paralytics demonstrates an intent to absolutely prohibit the patient from being able to breathe on her own, because pharmacologically and scientifically there would be no way for any of her respiratory muscles to contract, even if stimulated by her brain. So that demonstrates absolute intent to prevent the patient from being able to breathe. Secondly, the failure to use any form of a nerve stimulator or measure the impact of those neuromuscular paralytics on the patient prior to a consideration of removing the breathing tube and discontinuing the ventilator demonstrates the intent to hasten the patient's death, because the patient's death would be guaranteed. Thirdly, the decision not to attempt to reverse the paralytics prior to progressing to the extubation and the withdrawal of support absolutely demonstrates an intent to hasten the patient's death, because similar to the prior 2 observations, there would be no physiologic ability for the patient to breathe. Fourth, the administration of 2,000 micrograms of fentanyl in an 82-year-old patient with underlying medical problems would 100% guarantee that the patient would be unable to breathe within minutes of removing the breathing tube, and thus hasten and guarantee the patient's death. So I'm forced to conclude that that proves the intent to hasten the patient's demise. Fifth, the administration of Versed in combination with both the high-dose fentanyl and the nerve paralytics or paralyzing agents, which would synergize or increase the respiratory compromise of those other medications, demonstrates the intent to hasten the patient's death in this case by preventing or blocking any ability of the patient to breathe on her own. Also, the absence of seeking any consultation from the other doctors that were caring for the patient, particularly the doctor who had intubated Mrs. Penix only a few hours earlier in order to put her on the ventilator, demonstrates that there was an intent to hasten the patient's death. Additionally, the failure to seek consultation from palliative care and allow Ms. Penix's condition to reveal itself over the subsequent hours and days of admission, particularly to allow the antibiotics and the ventilator to support her care and see whether or not she could recover, demonstrates intent to hasten the patient's death.
Thank you, Doctor. Do you adopt all of the findings, conclusions, and opinions in your written report that have not been discussed?
Yes, ma'am, I do.
Thank you. One moment, Your Honor. Your Honor, that concludes our direct examination of Dr. Schweiger.
Okay.
I'll just need a minute to clear my things off.
Just gonna ask Ashley, do you need a moment to get organized here?
I don't, Your Honor.
Okay.
Thank you for asking. I just need a moment to move my things. Not a formal recess.
I just had her clearing stuff, and I was just thinking if you needed time, I would give it to you.
Thank you. Just need the notebook.
This.
Good morning.
Good morning.
Diane Menashe.
It's nice to meet you.
Dr. William Husel. Nice to meet you as well. I was going to begin my questioning with your credentials, but I have to start where you left off with respect to Ms. Penix. You talked a lot about the paralytics and that the paralytics, I wrote down, would guarantee the patient could not breathe. Do you remember telling this jury that?
I do, yes, ma'am.
You would know based on your training and experience that you cannot breathe. A person cannot breathe 7 times a minute when they're on a ventilator, right? It's not possible.
I would respectfully disagree with that statement.
You would disagree with that.
Correct.
A ventilator has settings, does it not?
It does, yes.
And the settings dictate the rate at which an individual is meant to breathe per minute. Is that correct?
Generally, that's a correct statement.
So you know then from Ms. Penix's medical records showing you the direct charting flow sheet that after she was extubated, she's breathing 7 times per minute.
Yes, that was documented, that's correct.
Still breathing.
In terms of attempting to initiate breaths, that's correct. That's what was documented.
Well, documented by nurse Wesley Black, RN, do you see that?
I do see that, yes.
And just so the jury's clear, we're talking about Melissa Penix. I want to make sure we have the right record, right?
Correct.
And we've got 11/20/2018 to make sure that we're on the right date.
True.
You just testified on direct that you didn't have any information with respect to the nurses testing or observing the effect, if any, of the paralytics. Do you remember that?
I do remember that.
Well, similarly, you don't have any reason, based on your review of the medical records or information that you were given from the state of Ohio, to refute the accuracy of that number 7, correct?
That is true that I do not refute the number 7, but that is only one aspect of minute or alveolar ventilation regarding how much oxygen and air is coming into the patient's lung, which can be impacted by the neuromuscular blocker.
Would it, and you know, Doctor, your rate for testifying in court is $600 an hour, is that right?
That's a true statement.
So for economy's sake, what I will do so that we can be efficient in our questioning is I will try, I'll take responsibility for this, to lead with the yes or no or correct. And of course, the state will have an opportunity to ask you some more questions after I'm done, okay? So you mentioned that you weren't provided any information from the state as to the nurses' observations as to what, if anything, they observed about Ms. Penix's ability to breathe. Remember telling the jury that?
I do, yes, ma'am.
Would it have been important for you to know that actually Wesley Black, the nurse in this case, in his sworn deposition indicated that actually he believed the medication were out of her system, that the vital signs were charted, the 7, and after she was removed from the ventilator, the family reported that she was breathing as well. Was that information that you were provided?
No, I did not see Mr. Black's deposition testimony.
So now let's go to your qualifications. showing you what's been marked as State's Exhibit 32A. Does that appear? I want to make sure, because I think there's a couple versions of your resume. Is that true?
Correct.
All right. So I want to make sure we have the correct version. Is this the current version?
It is, yes, ma'am.
And this is current as of what date?
January 1st of 2022.
And you indicated, well, let's just go through it. Let's start with this first position that you've indicated right here, the Director of Critical Care Medicine. Do you see that?
I do.
Let's talk about Florida Gulf to Bay Anesthesiology Associates. That's where you actually work.
Correct.
Because I heard you tell the jury, my hospital. Do you remember that testimony?
The hospital at which I worked, yes.
Okay, the hospital where you have privileges, is that right?
Correct.
And you used to have privileges at other hospitals as a function of working at Gulf to Bay, but you did not renew those privileges.
That's correct.
So you work at Florida Gulf to Bay, which is indicated over here by your employment.
Correct.
And I just want to make sure so that everyone sees. So the history of your employment is you were a professor, assistant professor from 1994 to 99.
Correct.
Tenure track.
Correct.
And then you're on a clinical track, professor, from 1999 to 2004.
True.
So for those 10 years, you were not practicing doctor.
No, that's incorrect. Every day I saw patients. I was employed by the university to work at Tampa General, delivering medical care to the patients that were at Tampa General, both in the operating room and in the ICU.
Do you remember at some point providing in a prior deposition the list of courses that you taught when you were a professor? Do you remember that?
I'm certain that I did, yes.
And you have given in your career over 200 depositions in civil cases?
Correct.
And we'll talk about those in a second, but let's go back to your resume if we could. So Florida Gulf to Bay is a for-profit LLC, is that right?
That's correct.
And Tampa General is a private not-for-profit, is that right?
That is my understanding. Obviously, I'm not on the board at Tampa General, but my understanding is that it's a private, not-for-profit organization.
Because you're not on the executive board at the hospital.
Correct.
And Gulf to Bay Florida Gulf to Bay has a number of offices. Is that right?
It has one primary office, but it serves several institutions.
And it's not just anesthesiologists, there's nurses there, there's other types of healthcare providers that work at Florida Gulf to Bay.
That's a true statement.
And so explain to the jury, because it didn't seem clear to me, when you do work at the hospital being Tampa General, you essentially bill them for your services. Is that how it works?
No, when we provide care for patients at Tampa General, Florida Gulf to Bay would bill on behalf of the physicians and nurses, the patient, the insurance company, or the government. We don't bill the hospital.
Right, so fair distinction. My point is that you're not paid an annual salary by the hospital.
Correct. I do not receive any salary from Tampa General Hospital.
So you go to Tampa General and you do, let's say, 10 services. Florida Gulf to Bay bills the hospital or insured or the provider for those 10 services.
They bill the insurance or the government for the services.
You do 20, they bill for 20.
Correct.
You do 30, they bill for 30.
That would be correct.
And you're noted as the Director of Critical Care Medicine. There's a number of different divisions at Florida Gulf to Bay.
There are, yes, ma'am.
You're not the president or CEO of Florida Gulf.
No, ma'am.
Because that would be Dr. Manjar?
Correct.
So then I want to go here to the indication that you're chief of the Department of Anesthesiology at Tampa General. As I remember from your direct examination that you told this jury that from 2019 to 2021 you were vice chief.
Correct.
Prior to providing the state of Ohio with this resume. You provided the state of Ohio with a different resume. Is that right?
Correct.
And that resume was provided, I presume, in conjunction with the first contract you signed, which was in January of 2020.
I believe so, yes.
Showing you what's been marked as Defendant's Exhibit Hans 20. Does this, let me show you the exhibit sticker. And Your Honor, for purposes of the record, we were provided a copy that was blacked out. So, does this look like the resume you would have provided when you were first retained by the prosecutor's office in 2020?
It does look like an older version of my curriculum vitae.
Okay, an older version was you supplied this to the state of Ohio in 2020.
Correct. It would have been earlier than the most recent updated version.
Sure. I just want to make sure, just so we agree on this, the vice chair position that you named is not on this document.
Correct. Obviously, I don't update my curriculum vitae every month, so this may well have been an older version of my CV.
And then I just want to be clear, so when you say you don't update your CV, you have things in your CV that say things like 2004 to present.
That's correct.
So when did you write the original report in this case? Wasn't it February 28th of 2020?
That sounds correct.
I just showing you what's been marked, the State's Exhibit 32B. Does that look like your initial report in this case?
It does, yes, ma'am.
I just want to go back. So we know this is February 28th of 2020.
Correct.
And I just want to go to your signature block on that same report. Tell me where it says that you're vice chair.
It does not list that there. Obviously, I can't list in a letter or a report every position that I hold.
Okay, let me then go to, for example, Brandy McDonald's supplemental report. And I'll ask more questions about this, but these patient reports you wrote, I noticed none of them are dated.
Correct.
Did you notice that?
That's true.
You wrote them.
I did.
Is that, we talked about the importance, I think you used the word meticulous on your direct. Do you remember that?
That is correct.
This case is all about records, right?
In terms of my involvement in the case, it would be specifically in terms of review of records.
And you talked about, for 2 days, the meticulous need for accurate record keeping, right?
In terms of patient care, that's absolutely true. I stand by that statement.
So that meticulous standard does not apply to your drafting of your reports?
I respectfully disagree with you. I've tried to be as accurate as possible. Of course, there are always times when certain typographical errors may be made.
Talk to me, though, about why you would have a policy where you don't date reports.
I don't have a policy. Obviously, this took a period of time to generate 14 reports on over 10,000 pages of records, so this was not all accomplished in one day.
Okay, but you would agree with me that your initial 14-page report has a date on it?
I would agree with that statement.
Okay, so going back to where I was, that you can't certainly put any titles, all of your titles on your reports. Just showing you as an example, Brandy McDonald State's Exhibit 32G, you have listed here, though, that you're chief. Do you see
Correct.
that? And again, though, we don't know the date of this report. We just know it's supplemental. Is that
That's
fair to say?
correct, yes.
Okay. And I'll ask more questions about that in a second. So tell me where I would go to determine that you're chief of the Department of Anesthesiology.
You could essentially go to the medical staff office at Tampa General. The election was believe last year, and it would confirm. I sit on the medical executive committee for the hospital, and in order to sit on that, you have to be a chief of a department or division.
And you have a LinkedIn account?
I do not have a LinkedIn account.
You don't?
I do not.
So showing you what's been marked as Defendant's Exhibit Hans 5. Does that appear to be your name?
Yes, that appears to be my name.
And does that appear to say anesthesiology and critical care medicine at Florida Gulf to Bay?
Correct, it does, but I have never created an account on LinkedIn, so I don't know who would have posted that other than perhaps if there was someone at Gulf to Bay who posted that.
Okay, and then showing you, because I know sometimes you go by Hans, don't you?
Yes, my nickname goes by Hans. Since my father's name was John, my mother used it to distinguish us.
Just in case there was testimony that you would have one, but it wasn't John, can you look at what's marked as Defendant's Exhibit Hans 6? That Hans, same last name, right?
Yes, that is correct. That also is the name that I go by. Most people know me as Hans.
And you would agree, would you not, that Activity 0 and experience is just listed as anesthesiology and critical care? And I want to flip to the second page so that, and that's my picture, but you would agree that that's the extent of Defendant's Exhibit Hans 6?
In terms of what's on that paper, yes, but this is nothing that I personally created. I don't use LinkedIn. I have no access to LinkedIn, and certainly this would not be what I would demonstrate. As it says, there's been no postings, no followers. It's nothing that I created.
Do you think it would be helpful to go to the Tampa General Hospital website and type your name in to see if there it said you were chief?
You certainly could do that.
Okay, showing you what's been marked as Defendant's Exhibit Hans 16. If I could, it's a 3-page exhibit, just taking you, does this seem to be 2022 Tampa General Hospital? Do you see that right there,
Yes,
Doctor?
that does appear to be the case.
Okay. And does this appear on Hans 16? It says your name there, and that's your middle name?
Yes, Walter is my middle name.
Okay. Just in Gulf to Bay, again, that's where you work?
That is correct.
And that is the address of Gulf to Bay, is not the General Circle address?
True.
And there it lists under your name, critical care medicine, anesthesiologist, and pediatric anesthesia.
That's correct.
And that's all accurate in terms of what you do in your capacity in terms of healthcare.
Certainly, it's not a comprehensive list. I do many more things at Tampa General. In fact, again, I don't primarily do a lot of pediatric anesthesia anymore. Early in my career, I did. So this is certainly an old posting of the things that I do at Tampa General.
So going back to the chief issue, Dr. Manjar is the one that founded Gulf to Bay.
That is correct, yes.
President and CEO of Gulf to Bay.
Correct.
And he also used to be the chief of staff at the General Hospital.
Correct. He was chief of staff probably 10 years ago.
And he was chief of anesthesiology at the hospital.
Yes, before me, he was chief of anesthesia for numerous years.
And I'm just, tell me, if it would surprise you, and Your Honor, I provided all this to the state. Tell me if it would surprise you, showing you what's been marked as Defendant's Exhibit Hans 7. Does that look like a picture of Dr. Manjar?
Correct, Dr. Mangar.
Mangar, thank you for correcting me. And it talks here about his experience. And then why I bring it to your attention is down here, it indicates that he is the chief of anesthesiology.
Yes, he was the chief before me. He's no longer the chief of anesthesia.
But
In fact, Dr. Mangar is actually retired. He no longer works at Tampa General.
and he's working with the Ultimate Human Experience, is that right?
Yes, he formed a new company, so that's why it says there, the Ultimate Human Experience. He no longer provides anesthesia, and he never did critical care.
Okay, I just want to be clear, though, that it says full-time and chief of anesthesia, right?
That's correct. He was the prior chief for more than 10 years.
But there was an election
Correct.
Okay. And before, your testimony to this jury is before you were chief, you were vice chief?
That's correct. Dr. Mangar ran as chief previously before he retired and was elected, and I ran as vice chief.
Here's why it's hard to find out. Would you agree that you don't have a website?
Yes, I do not advertise my services. I do not have a website. I don't use social media.
But I didn't ask you about advertising, because having a website that puts your credentials out for people to see is transparent. Would you agree?
No, I don't agree. Anyone who asks me for my credentials, I provide my curriculum vitae for. I think as a physician, maintaining objectivity is important, and just simply having a website, I think, crosses a certain ethical line, so I don't believe in that.
Okay, so let me talk about those ethical lines. Showing you what's been marked as Defendant's Exhibit Hans 3. Do you recognize that?
Yes, this is the fee schedule that I have, that I provide to various attorneys or other organizations who would request my services.
Okay, so would you agree with me right up here? Hans Schweiger, MD Consulting Services, LLC.
Yes, that's correct.
That is your own company through which you are an expert witness.
Yes, that's a true statement.
Okay, but you just talked about ethics, and certainly you talked on your direct about the need for transparency. You would agree with me, showing you what's been marked as State's Exhibit 32A, that under your employment, you do not list your expert witness company.
Correct. In terms of my academic curriculum vitae and what that I present there, that's independent from my work as a forensic expert.
It's employment, is it not?
I was encouraged to form my own LLC 10 years ago by my accountant and my attorney in terms of tax purposes, and I did as I was recommended to do.
I appreciate that, but my question was, your work as an expert witness through Hans Schweiger, MD Consulting Services, LLC, is employment.
Yes, I'm employed by the various attorneys or other organizations that would require my services.
Okay, so let's now go back to State's Exhibit 32A. We know this is the current version of your resume. We've talked about how you taught for those 10 years, and then you went to Florida Bay in 2004. Is that correct?
Florida Gulf Bay.
Florida Gulf Bay in 2004. Want to just make sure, and I'm going to flip through, don't mean to make anyone dizzy, but fair to say that on page 10, you begin to talk about the articles that you've published, and
Correct.
Between page 10 and page, let me get to it, 47, you talk, in addition to articles, about lectures you've given,
That's true.
chapters and books that you've written,
Yes, ma'am.
papers that you've presented.
True.
So pages 10 to 47, not one article is about palliative care, correct?
Yes, that's correct. I have not written on palliative care subjects.
Not one paper or lecture presented on palliative care, correct?
That's true.
Not one presentation on palliative care.
Correct.
Not one publication, book chapter, anything from page 10 to 47.
Object, Your Honor.
On palliative care.
Cumulative at this point.
Sustained.
So, which leads me to the next question. And you were deposed in relation to this case in a civil matter, were you not?
Yes, I was retained and deposed in this civil matter.
And you remember being asked in that deposition, I presume, about what training, if any, you had specifically in palliative care. Do you remember being asked that question?
Yes, that's correct.
And the answer is that you, between the years 1991 and 1994, as being at Temple University,
Correct.
heard some discussions or lectures about palliative care which equaled less than 10 hours.
I didn't overhear. I attended lectures that were provided by the senior faculty at Temple University directed towards palliative care. Prior to that, I had received training for a year in medical school that covered humanities and palliative care. And then obviously, since attending Tampa General, we've had annual conferences that include end of life as well as palliative care issues.
You were asked, and your undergrad is in religion, right?
That's correct.
You were asked in that deposition, were you not, other than the less than 10 hours of lectures that you heard between 91 and 94, you have no formal training in palliative care.
True, I've not done a residency or fellowship in palliative care, which would allow me to sit for the palliative care board exam.
The question was, you have no formal training. And you answered, that is correct.
Object, Your Honor, that's not what he testified to.
Happy to get it.
Okay.
I mean, in this proceeding.
I got it.
Thank you. One moment, Your Honor. Would it refresh your recollection to look at your deposition testimony from June 21st of 2001 with respect to this issue?
Certainly.
Page, please.
Page 19, if I may approach, Your Honor.
You said 2001?
It's June 21st, 2020.
Okay.
Direct your attention to that section right there.
Just review and then let me know.
Okay, I've read that part.
Thank you. Refresh your recollection. Fair to say that in answer to the question after that training, which was the less than 10 hours, have you had any other training in palliative or comfort care? You answered, so no formal training.
Correct. And then I go on to say that I've attended regular conferences at Tampa General administered by the palliative care team. So once again, I have not sat for a residency in palliative care, so I would not be eligible for the board exam, but that does not mean that I do not have annual experience in education in palliative care and end-of-life issues.
Just the question about formal training and your answer. Thank you, doctor. I appreciate it. So let's go on now. We've established your resume. Let's go now, if we can, to the contracts that you signed in this case. You signed an initial contract showing you what's been marked as Defendant's Exhibit Hans 2. The date of this is January 31st, 2020. Does that look correct?
Yes, ma'am, that does look correct.
All right. And in this contract, it just simply states that your fee is $500 an hour.
True.
And appears to be your signature on the back page.
That is, in fact, my signature.
You would agree that there is no cap on this contract?
To my recollection, there was no cap when I read the contract. The contract was provided to me by the prosecutor's office. I did not draft it.
They generated this contract.
That is correct.
And then you signed it, right?
After having read it, then I signed it.
I noticed this section down here, A, a billing schedule is semi-monthly on the 1st and 15th. Tell me how many invoices under this first contract have you submitted for payment?
I've only submitted one invoice for payment.
Okay, and when did you submit that invoice?
I believe it was in early 2021.
And you have someone that you're consulting that does your bookkeeping?
Yes, my daughter, who's a graduate student, is employed by the LLC to help me with administrative staff. She works a couple days a week in the afternoon, and she helps me with PowerPoint and those type of things. Certain bookkeeping that obviously I have no familiarity with.
So there was an invoice generated. What was the amount of the invoice?
To my recollection, it was approximately $12,500 in that range. It reflected approximately 25 hours of original work reviewing all the medical records and generating the first report.
And this was up to 2021?
Correct, early 2021.
And $12,500.
Correct. It may have even been submitted at the end of 2020, if my memory serves me correctly. It may have been December of 2020. I don't think it went into 2021.
just wanted to make sure I heard you say clearly when the invoice was for. Showing you what's been marked, State's Exhibit 32B. Again, this looks like your report from February 28th of 2020. Would you agree with me on that?
I do agree with that.
And this report is addressed to individuals that used to be prosecutors here in Franklin County, Ohio.
That's a true statement.
And you indicate here, do you not, that as part of the medical review, you have reviewed carefully the following records. And then without going through, it is fair to say, is it not, that you, as part of the February 2020 report, reviewed 25 patients?
Correct. As part of the initial review, I was asked to review 25 of the medical records, and I did do that.
Okay. And the report, do you draft your own reports or do you dictate them, just as a matter of policy?
Now, as a matter of policy, I type my own reports. My daughter has no medical or nursing training, so I do all my own work. Sometimes I just ask her to proofread if I haven't had time to proofread, but she's just going by grammar.
Sure. So then you would have drafted this report yourself?
I did, yes, ma'am.
Which means then that between signing this contract, January 31st, 20, and writing this report, there are essentially 30 days that passed. 29 days, right?
Correct.
And I ask you this because I think you just said that you invoiced for work through 2021 that was for 25 hours.
Correct.
And you're aware that this part right here only has the records of 14 patients.
That's a true statement. There were some cases that I initially reviewed that I was not asked to write individual reports.
So if I may approach, Your Honor, just as an example,
Doctor, I'm showing you State's Exhibit 14, Melissa Penix. Would you agree that these binders, visually they appear to be a certain size, but the pages are actually double-sided?
That's correct. In these binders, each page appears to have print on both sides of the page.
So however thick they appear, we could assume they're kind of double the size.
Yes, if they were individually printed, they would in fact be double the size.
and in this report, you let Mr. Lowe and Mr. O'Brien know that you reviewed all the records of the 25 patients.
Yes, that is correct.
And you did that in 25 hours.
Correct.
I also think I remember from the deposition that that 25 hours included some consultation time with the prosecutors as well, did it?
That's correct. I did have a phone call with the prosecutors to report verbally my findings, having reviewed the medical records.
And while you were asked to review 25 patient files, happy to have you look at the list right here. Fair to say that you were not asked to review the patient file of Tracy Young.
Correct. I was not provided the file of Tracy Young for my initial or subsequent review.
But you are aware now, as you sit here, and have been made aware through the work on this case, that Tracy Young was given...
Object, Your Honor. Move to approach.
Yes. Ladies and gentlemen of the jury, have a conversation. David will be out. Okay, the objection sustained. Let's proceed on.
Thank you, Your Honor. But no, I asked you the question, did the prosecutors provide you with records that belong to a patient named Tracy Young? And I think for transitional purposes, you said no.
Correct. That is a true statement. I was not provided medical records for Tracy Young.
And you are aware Mr. Schweiger, Attorney Schweiger, is the attorney that hired you in the civil case against Mount Carmel. Is that correct?
Yes, that is correct.
Mr. Schweiger, however, provided you with some records belonging to Tracy Young. Is that a fair statement?
It is correct. Right prior to my deposition, when I met with Mr. Schweiger, he presented me a few excerpts from a chart that was labeled TY, that I believe to be Tracy Young, in preparation for the deposition testimony in the civil trial.
And during the deposition in the civil trial, were you asked questions about Tracy Young?
To my recollection, there were some questions posed by the attorneys for Mount Carmel West about patient TY.
And at that time, on June 21st of 2021, fair to say that you had enough confidence based on the review of what you were provided to testify as to dosage amounts that Tracy Young had been given by Dr. Husel during her palliative extubation.
Yes, that's correct. Mr. Schreier had shown me some of the dosing schedules that patient TY had received from Dr. Husel while she was a patient.
And specifically, you gave dosage amount, did you not, as to what she was given with respect to the palliative extubation?
Correct. Based on the limited records I have, I answered the questions that were asked of me by Mount Carmel's attorneys regarding what I had seen regarding patient TY.
And you indicated, did you not, that she, it was your understanding, based on the review of the records you had been provided.
Your Honor, page, please. I'm
Page
trying to follow along.
Page 246, the
Thank
data.
you.
The patient had 2,500 micrograms of fentanyl, 20% and 16 Dilaudid over 37 minutes. Do you remember that testimony?
I do recall that, yes, ma'am.
And then lastly, with respect to your testimony that you gave under oath in the deposition with respect to Tracy Young, she lived for 9 days after her extubation, did she not?
Yes, based on the limited review I had of the medical records provided to me by Mr. Schreier, that did appear to be true, although that was a patient who had tremendous exposure previously to opioids and had developed true tolerance to the medication.
So then tell me, if you made that determination about Tracy Young, that she was not opioid naive, you must have then been given a large volume of records, which would have included the MARS and her home medication history. Were you given all those records?
No, I was only provided excerpts of her medical records by Mr. Schreier. I did not have access to the entire chart.
Would you agree, in your work as an expert and your work at Florida Gulf to Bay, that you're only as good as the information you receive?
Certainly, the information I receive helps determine the accuracy of the analysis of a physician in caring for the patient or of an expert who's providing analysis of a medical record for giving testimony.
As you sit here today, you have no reason to disbelieve the statement you gave in the deposition with respect to the dosage amounts, correct?
Yes, that's a true statement. I gave the best answer I had based upon the limited available information I had regarding patient TY.
And the same is true for how long she lived, which was 9 days.
Yes, based upon the abstracts I was provided, it appeared that she had lived for 9 days.
Let's go to now your statement on direct with respect to how you spend your professional time. I know we've already gone over that on your resume you don't list your consulting company. But as I wrote down your testimony, it was that you spend 95% of your time treating patients, and then you said 5% on administrative work. Do you remember that answer?
Yes, I do remember that answer.
And 95 plus 5, and then is 100.
Correct. In terms of my actual work at the hospital, it would be broken out as 95 plus 5 is 100. In terms of then total time, 10% is on consulting and 90% is on the practice of medicine.
I thought you told this jury on direct that 15% of your income was from your expert testimony.
That's true. 10% of my time and 15% of my income.
How many hours do you work a year? Just on average.
So I work on average 70 hours a week as a physician.
As a physician, and then on top of the physician, you do expert time?
Correct. And then another 7 or 8 hours a week doing forensic consulting.
And you told this jury that you get about 15 new cases a year. Is that fair?
I receive between 18 and 20 new cases a year.
As for those cases, let's talk about how they come in. They come in and you review them. Is that the first step, as I understand it?
That's a true statement.
And then, if necessary, you are asked by the individual that hires you to create a report and then potentially do a deposition. Is that right?
So it depends upon the jurisdiction. Certain states do require reports. All federal cases require experts to write a report. Many states do not require a written report by the expert, but instead will require a deposition in which the attorneys ask the expert questions. So it depends upon which state and jurisdiction the expert reviews cases.
And doctor, I'm looking for economy here. So I will leave my question with the yes or no, but you then, after you're retained, you review the case, and then in some cases you give a deposition, correct?
True. In some cases, I would be asked to give a deposition.
And then in some cases you testify at trial, correct?
Correct. In a smaller number, I would be asked to testify at trial.
You remember, well, let's talk about that. In advance of any depositions or trial testimony, you would agree with me that you meet with the attorney that hires you. Is that right? To prepare?
Yes, that's a standard experience that I would meet with the attorney for 1 or 2 hours prior to a deposition or a trial testimony.
And what's of those 15 to 20 cases a year, how many hours would you say on average you spend on a case?
On average, it would probably be about 8 to 10. It may be as little as 1 or 2 if I reject the case and do not get involved in the case, or it could be more than 10 if I have to review extensive deposition testimony.
I wrote it down, but I just want to make sure. On your direct, were you asked about how much of your work is done for the plaintiff versus the defense?
I believe I was, yes.
And I think you kind of said like 50-40. Do you remember that answer?
No, the answer is 60% for the plaintiff and 40% for the defense.
Okay. And I want to just, so the jurors are sure. The plaintiff, this is the first time you've ever testified in a criminal case.
That's correct.
You, by practice, through your consulting office, are hired as an expert witness in medical malpractice cases.
That's a true statement.
Do you remember the deposition you gave in the Janice McKinley versus Advocate Northside Health Network case in 2017?
I don't recall that specifically.
In that case, let me ask this. Sometimes in cases you're asked to provide a trial list in civil cases. Is that true?
Yes, that's true. In all federal cases, you have to present a deposition and trial list.
And I was just going to say, and so you put this list together with intention and time, and then you provide it to opposing counsel and your counsel. Is that right?
True.
And in that deposition in 2017, you were asked, were you not, about the number of cases. Let me ask you this, since you said you don't remember. In 2017,
Diane, thank you.
does it sound, if your trial list represented 165 cases, is it your testimony to the jury that that is essentially a 60-40 split? Plaintiff's defense work?
No, in terms of depositions, 90% of the time I'm asked to give a deposition, it's on behalf of the plaintiff, and 10% on behalf of the defendant.
And actually, in 2017, does this sound right, that your trial list was 165 cases, and of those, only 9 were for the defense, so 5.4%. Does that sound right?
No, it does not sound right, because in my entire life, I've only done 35 trials, so I've not done 165 trials. That would be, they probably were asking about both deposition and trials.
That's true,
Yeah.
deposition and trial.
Correct.
165, 9 were actually for the defense. Do you remember, does that sound right, as of 2017?
No, I've done more, because I had 3 trials for the defense, and then certainly more than 9 depositions for the defense.
Would it refresh your recollection if I were to show you a certified copy of your depo transcript in that case?
Certainly.
Thank you. Showing you that for purposes of the record, the transcript is from December 7th, 2017.
What's the marker on it?
Yep. I will provide the copy of Hans 21, Your Honor, that is exhibit. And Dr. Schweiger, I'm going to provide you with the same pages, but my copy's marked up. If you could read page 20, to refresh your recollection, 21, towards the bottom is where I've asked those questions. And then following on page 20, or 21. Let me know when you're done.
Since he's going to be reviewing that, it's getting to be break time.
Now, let me just finish this and then.
Okay.
Okay, I've read this.
Great. Fair to say that, and if you want to, I should have given you this, because this, do you see your name on top there?
I do, yes, ma'am.
Okay. Now that you've had an opportunity to review page 22 and 23, fair that you were asked about whether 5% of the 165 was an accurate number, and you indicated, I haven't done the calculation, but I would accept that if that's what you calculated.
Well, actually, that's not true. On page 22, I answered, if that's your calculation, I haven't done the calculation, but I would accept it that if that's what you calculated.
Right. No, I'm aware of that. And in the prior page, it says 165 and 9 cases are listed as the defense. Do you see that at the bottom of 22?
Correct, and he said it's my math, that's 5.4%, because my estimation is 10% for the defense and 90% for the plaintiff.
And here's why I asked this. Thank you. Judge, I'm almost done. Here's why I asked this, because I remember in your direct testimony, you said something about, what was the phrase you used, hindsight bias?
Correct, as an expert, I try to avoid hindsight bias.
Almost in every deposition, fair to say, you were asked, are you not, which side do you testify more frequently for? Which?
That's a true statement.
Because as an expert witness, I assume you understand that the intent of that question goes to bias.
I can't presume what the attorney is intending by the question. My answer is always consistent, that I attempt to be objective and avoid hindsight bias.
One more question on that. You can't infer what the intent is for an attorney asking a question, but you testified, and we'll get to it, on direct with respect to every one of these cases as to what was in that man's mind. Is that right?
That's correct. In terms of the...
There's no transference between legal and medical knowledge.
Okay. I'm going to overrule the objection for now.
Thank you.
Let's take a break. 15 minutes, guys. Okay? Dave?
All right.
Darcy? Ms. Schaefer? Have a wonderful break, guys.
Thank you.
You can be seated. Ms. Menashe?
Yes, Your Honor?
Would you be kind enough to mark your copy as prime? Hans, I think it was Hans 20, defense Hans 20 was the one you showed him,
Sure.
and then you showed him an additional document that was your version. So just for the record, have it marked so that the court reporter can have it when it's done.
Do you mind if I take the sticky note off?
You can take a sticky note off.
Perfect. Sam will get you that copy. Sure. I think we have to mark it as primary.
Anything for the record, Ms. Grubb?
Nothing else, Your Honor, thank you.
Anything for the record, Ms. Menashe?
No, Your Honor. We have-
Okay, we're on break.
This one.
testimony, doctor, you're still under oath. Ms. Menashe.
Thank you, Your Honor. Good. Switch gears and go over some of the things that you testified to over the last 2 days. You were asked with respect to every patient about pain scores. Do you remember generally being asked about pain with respect to every patient?
Yes, ma'am, I do.
And for purposes of my questions today, let's assume that we're talking about terminal palliative extubations. Okay?
Understood.
All right. With respect to terminal palliative extubations, you would agree, would you not, that part of the use of the medications is to help ease not only the pain and the mental anxiety of the patient, but also as a collateral effect on the family members that are present with the patient?
I would generally agree that the role of the pain medicine is to reduce any pain that the patient is experiencing or potentially might. Again, the patient is always the primary responsibility of the physician, and then, of course, you try to support the family during these emotional times, but you don't medicate the patient simply based on the family's request.
Wasn't my question. And do you remember being asked that exact question during the deposition on June 21st of 2021?
I recall a similar question, not necessarily the exact question.
And at that deposition, you answered, did you not? Yes, I agree. And then you went on to say one of the goals in both the palliative care team and the ICU team of who were involved is to make the transition from life through the dying process to ultimate death as tranquil and peaceful as possible. Do you remember that being your answer?
Yes, that I do, and that I endorse.
So when you kept being asked during direct questions about just pain, fair to say you were never asked any questions by the prosecutor about mental anxiety of the patient. That is correct, is it not?
Yes, I don't recall a specific question about mental anxiety.
Nor were you asked any questions by the prosecutor about the psychological and or anxiety that, based on your experience in training, a family might experience, for instance, seeing a bad death. You weren't asked questions about that either.
I don't recall a question asking that particular concept.
I want to show you what's been marked as Defendant's Exhibit MCD 15. You are familiar through the work in these cases with the order sets at Mount Carmel Hospital. Are you not? I
am, yes, ma'am.
Okay. And this is MCD 15, and also showing you what is marked as Defendant's Exhibit 1516.
True.
Okay. Would you agree with me that the order sets, while they appear to be the same, have different effective dates?
That is correct. There's 3 years approximately, or 2.5 years between those dates.
I want to talk to you about order sets because you're familiar with order sets because they have them at Tampa General, do they not?
They do, yes.
And they have an order set with respect to terminal ventilator withdrawals, right?
We do, yes. We've had one for more than a decade.
And in the Tampa General order set, fentanyl is included as a listed medication that one could use.
Correct. It is an option available for the physician to check off and potentially use on the patient.
And you are aware, I'm sure, based on your review of Defendant's Exhibit MCD 15 and or MCD 16, that fentanyl is not included in the Mount Carmel order sets.
That is correct. I do not see that listed on that page up on the screen.
And of course, let me know if you need to look them over, but you would agree that fentanyl in appropriate doses is appropriate to use during a terminal ventilator withdrawal, correct?
Yes, in terms of its use in judicious, appropriate, incremental fractionated doses, I do believe it can be used appropriately.
And you know, do you not, that the order sets at Mount Carmel West were not mandatory?
Correct. I did learn that through my review, that the order sets were not mandatory at the time that they were put into effect.
But you know of their existence, and so I want to change to the topic of paralytics. I think you told the jurors yesterday, and tell me if I'm wrong, but you said, did you not, that paralytics need 3 hours to leave the system before an individual is terminally withdrawn from a ventilator? That was your testimony, was it? 3 hours?
My testimony is that in order to guarantee that all the effect of the paralytics have been removed from the body, you need the 3-hour mark, because the half-life...
Doctor, and
Object. Please
Again.
let him finish.
Okay, stop. We got an objection, overruled. New question.
So the 3 hours is to be safe, is what you tested.
Correct, to be safe.
I want to show you the order set of belonging to Mount Carmel West, MCD 15. Do you see that?
Yes, it highlighted...
There's not a question on the floor, doctor, so just give me a minute.
Well, you're asking, did you see that?
Okay. Yes or no, do you see that?
Yes.
You would agree with me, would you not, yes or no, that the highlighted section says, comments, discontinue paralytics 30 minutes prior to ventilator draw. That's what Defendant's Exhibit MCD 15 says, correct?
Yes, that is a true statement.
And then I want to turn to MCD 16, because we know they deal with different years. You would agree, would you not, yes or no, that the same language, discontinue paralytics 30 minutes prior to ventilator withdrawal, is, again, appears?
Yes, the same language does appear in both protocols.
You would also agree, would you not? You talked a lot about consult with the palliative care team. Yes or no? You are aware that Mount Carmel did not have a policy that prior to a terminal vent withdrawal, the palliative care team needed to be consulted?
Yes, I was aware through my review that Mount Carmel West did not have a policy mandating palliative care on each and every case.
And even further that point, you would agree with me, would you not, that on these order sets, there is no box that indicates that the palliative care team must be ordered or called, correct?
Yes, it's true that I do not see on these protocols a box that would be checked to directly consult palliative care.
So when you testified during all those patients about the palliative care consult, that wasn't mandatory at Mount Carmel West?
It was not mandatory, but it should have been part of the process of terminal extubation and withdrawal of support.
So if you had been a CEO of Mount Carmel West, as I understand it, that's your testimony that that would have been the preferred practice?
If I was the chief of the medical staff instituting policies for the physicians, yes, I would have made sure that the policies at Mount Carmel West required that the mandatory consultation of palliative care be ordered before the withdrawal of support.
So yes.
Correct. Other than, obviously, I'm not a businessman or CEO, but as a physician
Right.
who would be serving that position, yes, I would have mandated it.
You know, so, talked a lot about vasopressors. You're familiar with the package inserts, are you not? Showing you what's been marked as Defendant's Exhibit MCD 18. Let me increase this. Yes or no? The word that's highlighted up top says levofed, is that right?
Yes, that does say levofed.
Okay, and that is it not a vasopressor?
Correct. Levofed is, in fact, a vasopressor.
And I just want to, again, Defendant's Exhibit MCD 18, because I want to go back to that testimony about Ms. Penix. What you were talking about, the paralytics. This is a different issue when you talked about how a vasopressor
ending a vasopressor would hasten death. You would agree with me that the packet insert, or Levofed, indicates that the pressor action stops within 1 to 2 minutes after the infusion is discontinued. Do you see that language, doctor, yes or no?
Yes, I do see that language in the package insert.
So what that means, does it not, is that once the vasopressor is stopped, presumably by a nurse, it takes 1 to 2 minutes for that medication to stop having its known effect on me. Correct?
It is true that within a minute or two of the vasopressor being terminated, that the direct action at the receptor would fade and would stop.
And you know that as part of any terminal ventilator withdrawal, that vasopressors are stopped before the extubation. You know that.
In most situations, if the decision is made to remove life support at the time of the terminal extubation, yes, the decision would be made to then terminate the vasopressor administration.
Okay. Because a vasopressor is a form of life support, is it not?
Not in all situations, but certainly in patients who are requiring them to maintain adequate cardiac and blood pressure function, it would be true.
Okay. So you turn the vasopressors off and they leave the body system in 1 to 2 minutes. I think your testimony with respect to one of these patients was how the vasopressors termination hastened death. Do you remember that testimony?
And just to be precise, they don't leave the body in 1 to 2 minutes. It's the effect that's lost at 1 to 2 minutes.
Okay, doctor. It'll help out. She asked you a direct question. You went off to a tangent. Let's answer her questions, okay? Ms. Grubb will have an opportunity to clear up any mistakes or anything.
Could we have the question reread?
The effects of the vasopressor are gone from a patient's body in 1 to 2 minutes, correct?
Generally, that's a correct statement.
And your testimony, was it not, yes or no, at the end of your direct exam, that stopping the vasopressors was hastening death? Do you remember saying that to this jury?
I do recall that, yes.
Well, by that same logic, taking the tube out is hastening someone's death as well, is it not?
It could potentially hasten their death if they can't breathe on their own.
If they're vent dependent, right?
If they're completely vent dependent, that would be a true statement.
We'll talk about that in a minute. But first I want to go to your testimony with respect to obesity. Showing you what's previously been marked as Defendant's Exhibit MCP1 and MCP2. Are you familiar, through perhaps your work in the civil case, the Mount Carmel policy and procedure with respect to the guidelines, the administration guidelines? Are you familiar with this?
Yes, I believe I have been presented this in my review of the civil case.
Okay. And I want to show you that this is the 17 version of the same policy. If you know, there's 2 different versions because 2 different dates. Does that sound correct, doctor?
It does sound correct.
Just want to take you to, because I thought your testimony, you talked for some time about how if you're obese or have a particularly high BMI, right?
True.
That you gave testimony about how your practice would be to give less drugs. Do you remember that line of testimony, yes or no?
Yes, I do recall that.
You're aware then from your review of the Mount Carmel medication administration and self-administration guidelines, number 22, that reads, and tell me if what I read is what you see, doctor. Sometimes particular patient conditions warrant giving medications outside of the IV guidelines specification. And then it says, does it not, doctor, i.e. obesity, pain control, intolerant patients, palliative care.
Yes, that's what number 22 does read.
And same respect to the 2017 version. In this version, it's number 23 as opposed to 22, but you would agree, would you not, that it says the exact same language, that if it's obesity, pain control, intolerant patients, or palliative care, you can go outside the IV guidelines. That's Mount Carmel's policy. Would you agree with me on that?
Yes, I would agree. That's what the policy states and is highlighted.
Exhibit numbers again, Diane.
MCP 1, MCP 2.
Thank you.
Let's talk about overrides briefly. I know you were asked a lot of questions about intent. Just so we're clear, when you were asked questions about what actions or lack of actions by Dr. Husel, you have no words of Dr. Husel other than the medical records, correct?
That is correct. I've not been presented a deposition testimony.
There's no deposition.
True.
Right? And in those medical records, with respect to the issue of intent, there are no words that say, I want to hasten this patient's death. Correct?
That's a true statement.
There are no words that say anywhere in any of these hundreds of thousands of pages of medical records, I include the 25 patients, that it says anywhere, I want to kill this patient. Correct?
That's a true statement. I do not see that documented in the record.
In fact, there's nothing with respect to words that indicates any motive or reason why Dr. Husel would want to somehow hasten the lives of these patients, right?
True. There's nothing documented in the medical record as to that topic.
So I want to go to overrides because, and I reviewed your deposition testimony, and I want to talk about why it's relevant. Would you agree with me that you did 14 summaries for patients?
Correct.
These are supplemental.
True.
At the end of it, end of each one, and I want to show the jurors, this is State's Exhibit 32C. You have this paragraph, do you not? The same paragraph appears at the end of each of the 14 supplements. Correct?
Correct.
And it says specifically, all of the answers I provided in my prior sworn deposition testimony related to this and similar cases were true and accurate.
Correct.
And that language appears at the bottom of every single one of these 14 reports.
Yes, it does.
And I assume before you would make an assertion like that as to the accuracy of your deposition, you would have reviewed that June 2021 deposition to know exactly what you had said.
Yes, I did.
And so with the issue of overrides, you were asked about how, if at all, the frequency of overrides came into or was a factor in your consideration in this case. Do you remember that line of questioning?
Generally, I do recall that line of questioning.
And you talked about how overrides could be used to infer intent. Do you remember that?
I do remember that.
Showing you what's been marked as Defendant's Exhibit MCD and MCD4. Doctor, have you ever been provided with this document?
No, I don't recall seeing this specific document.
Just want to go over it with you, given what you said about overrides could be a factor in determining intent. Are you aware that the ICU floor at Mount Carmel West had 3 Pyxis machines?
I don't recall a specific number, but I was aware they did have Pyxis machines.
And you are aware through your training and work about what an override is without having to define it, because the jury knows at this point. But you know what it is.
True,
Okay.
yes.
So I just want to go back to this. So if we look at this, does it appear to say 2017, the calendar year of 17? Do you see that?
Yes, it does.
And Station 1, 16,000
510, do you see that?
I do see that.
And I'm just including the notes that I had previously made, MCD 5. Then I want to flip to the second page. Station 2 is 11,600. Do you see that?
I do see that.
And then I'm going to go to the third page. Station 3 is 8258. Do you see that? Oh, I'm sorry, 8258. Do you see that?
Correct.
Okay. And if it, over here, does it appear that I've summarized those numbers in my handwriting with respect to 2017?
Yes, I see that.
And then I want to go to 18, MCD 4. This appears, does it not, to be the calendar year of 2018?
Yes, it does.
Mount Carmel West.
Correct.
And Station 1, 17,562. Do you see that
True.
number? Station 2, 10,785.
That's correct.
Good, I caught my math there. And then here, 8521. Do you see that?
Yes, I do see that.
So, and I have these totals here, and this would obviously be +3, but you would agree with me, would you not, that those totals, those numbers I was giving you, are over 36,000 overrides on the ICU floor in one calendar year?
Yes, that's accurate.
But you were not provided this information prior to making your determination and testifying in your deposition with respect to intent. Is that right?
That's true. I have not seen that document.
That's a lot of overrides, isn't it?
It is a lot of override.
Overruled.
Let's turn to the articles.
They're QRS, and they're up there. I took them out and put them on the left corner.
Oh, thank you. Appreciate it. I want to first show you, you testified on direct and also in your deposition that there was 5 articles that you review and rely upon in your findings and conclusions in this case. Is that fair to say?
Yes, that's a correct statement.
And I think the authors of those are Streisand, Stanley, Shlomo, Cook, and Hunai.
Correct.
So you were asked about this article, States Exhibit 32Q. You would agree with me that this article was the Truig article that you were asked about, correct?
I would agree with that statement.
And that's not one of the 5 articles that you mentioned in your deposition testimony regarding what you relied upon with respect to peer review literature, right?
That's correct.
But I just want to make sure that when you spoke about this article, you talked about how this was a later version of a prior reiteration of this article. Do you remember that testimony?
I do remember that.
And did you say, in connection to that testimony, that I think this was a 2012, but there was a 2000, what year version?
It may have been 2007. I have to go and specifically look at the reference. It was in the prior decade.
Okay, and I'm not trying to hold you to the date. I'm asking because I think you then followed up with, it's important to update things because in medicine, things change in advance so quickly.
Yes, that's a generally correct statement.
I want to go now to the article you were asked about, States Exhibit 32R. Does this look like one of the articles that you were asked about?
Yes, this is the Bailey article with senior author Stanley.
Okay. And so I just want to be clear about this article. It's published in 1990.
That's a correct statement.
And with respect to
this article, none of these patients were dying, undergoing terminal vent withdrawal.
That's a correct statement.
So this article doesn't have to deal with terminal vent withdrawals at all.
No, they were looking at healthy volunteers in this study.
And so that's another thing. They were looking at healthy volunteers, right?
True.
And if you know, 1990 was the year that the World Wide Web was established?
In that area, yes. I don't know the exact date, but I think I was familiar with that area.
And 90 was 32 years ago?
Correct.
And the definition of healthy is not defined in this article. Would you agree with me on that?
Correct. The authors certainly indicate the exclusion criteria, but they don't give a specific definition for the word healthy.
And that's that first article. I want to talk about the second article that you talked about on your direct. I'm showing you what's been marked at States Exhibit 32. I think it's S. Is that right?
I can't see it. It's on the bottom. Yes,
Do you see that?
I do see that now.
And if you could agree with me, and I'm happy to zoom in if you can't read it, but this article is from 1993.
I agree. It's 1993 published date.
And this is the Streisand article, is it not?
Correct. Again, the Streisand with the same senior author, Dr. Stanley.
And I want to just make sure, and it's not my exhibit, so tell me if you need me to zoom in, because I don't want to highlight. Okay. This study looked at 12 healthy adult males.
Correct.
That was the universe, 12 people.
Yes, that was the study group.
And this article, like the last article, of those 12 people were not people that were dying or undergoing a palliative terminal vent withdrawal. Correct?
I agree. None of these were undergoing a palliative vent withdrawal.
Then I want to talk about the two other articles that you mentioned that you relied upon but you were not asked about in direct. Showing you what's been marked as Defendant's Exhibit Hans 4. And these highlighter marks are my own, and I will provide a clean copy to the court. Do you agree with me that the author appears to be Cook on this article?
Yes, the senior author was Dr. Cook.
And for purposes of the jury, this article is authored in what year?
It was authored in 2010, so 12 years ago.
And this is, again, one of the peer review articles that you mentioned in your deposition as relying on in this case.
That's correct.
This article, this study, was 1,505 adult patients, correct?
Yes, that's true.
14 hospitals in Washington State.
Correct.
And this article does deal with patients that were terminally withdrawn from life support.
I agree with that statement.
And this first sentence right here, does it not, says little information exists about the expected time to death after terminal withdrawal of mechanical ventilation.
Yes, that was the author's first sentence.
And then the conclusion, and you've written articles yourself, so the conclusion is the ultimate finding, is it not?
True.
States time to death after withdrawal of mechanical ventilation varies widely, yet the majority of patients die within 24 hours. Do you see that?
I do see that, yes, ma'am.
And then the next sentence, I'll include it for purposes of inclusion. Subsequent validation of these predictors may help to inform family counseling at end of life.
Yes, I agree with that statement.
And then going, if we could, same article, because I'm sure that you've reviewed and know this article, is the discussion section right here. Just want to make sure that I'm reading this as you are, is that our studies show that approximately 50% of patients, and again, the study in this case is 1,505, those that are being withdrawn terminally from a vent, right?
Yes, that's true.
Of that population, 50% die within an hour.
Correct.
And approximately 90% die within the first 24 hours.
Yes, that was the author's findings.
The majority of and the article and discussion goes on, does it not? The majority of the significant independent predictors that we identified include the acute severity of illness, right, doctor?
Yes, that's true.
With greater acute severity of illness,
Correct.
predicting shorter time to death.
Yes, that was the author's conclusion.
And then the final sentence says these predictors include the number of organ failures,
That's correct.
use of vasopressors,
That is true.
and the use of IV fluids.
Correct.
And just so we're clear, the number of organ failures, that could include kidney, liver, heart, cardiovascular, right? Brain.
That's true.
Those are all organs.
Yes.
And this article, like this article, is showing you what's been marked as a Defendant's Exhibit Hans 12, is something that you're very familiar with.
Correct.
And the date on this article, is what, if you could tell the jury?
2013.
And it's published in the Journal of Palliative Medicine, is it not?
That's correct, it was.
And this article, just so we're clear about the universe of people or individuals that are being spoken about in this article, it dealt with 322 ventilated deaths.
Correct.
So like the Cook article, this is actually dealing with patients that are dying after a terminal vent withdrawal.
That's true. The population of study was similar to the Cook group.
And right here, and again, this is my highlighting, but I did it just for ease. The results say, do they not, the median time to death was 0.9 hours.
That's correct.
The range was 0 to 165, right?
Correct.
And then it goes on to say, essentially, some numbers with respect to the oxygen, right?
True.
And vasopressors and how those can be considered in the duration of time of death. Do you agree with me on that?
I do agree with that statement.
Just want to make sure, though, that we agree on this, because you've written articles, and I know you've reviewed them. The range is what's reported as found in the study, right?
That is correct. That's the range means from the shortest period of time to the longest period of time.
And so you would agree with me, we don't know how many, but there was at least one patient in this 322 demographic or universe that had a death time of less than a minute.
Yes, based on their data, that would appear to be correct.
And then I want to go on in this article again, that it talks here, the article does rather, in terms of the introduction. Palliative withdrawal of mechanical ventilation, defined as the withdrawal of the ventilator, in a patient expected to die, is part of the transition to comfort-oriented care that is appropriate, quote, once it is decided that further aggressive medical care is incapable of meeting the desired goals for a patient. Do you see that?
I do see that, yes, ma'am.
Do you see that the last word there is patient?
Correct.
It's not the desired goal for the doctor.
I would agree with that.
And you know, do you not, that when someone is on a ventilator, communicating with them is obviously very difficult.
It is more difficult than if a patient is not on a ventilator. That is true.
And certainly when someone is in a deeply sedated or in a coma, those are situations where how we learn what the patient wants is through their next of kin or their durable power of attorney.
Yes, given the situation where they may well be deeply sedated or comatose, one would have to depend on the next of kin or any written documents such as a power of attorney they may have created prior to their illness.
Because in the absence of a patient being able to speak for themselves, those individuals or that document
document speaks for them.
That's correct, generally true.
Well, you are aware, are you not, doctor, and I think it might be different in Florida, that if consent is withdrawn in Ohio, that is, if a durable power of attorney makes a decision that their loved one should be palliatively extubated, that doctor, that attending physician.
Your Honor, may we approach?
Yes. Ms. Schaefer? Ladies and gentlemen? Gentlemen of the jury, the objection sustained. You want to rephrase?
Yes, Your Honor, thank you. If you know, in Ohio, is a physician still allowed to treat a patient after a durable power of attorney or an next of kin has withdrawn consent?
I am not familiar with that specific aspect of Ohio law.
When I go back to the article with respect to, and how do you say this name, Doctor?
I believe it's pronounced Hun.
Hun. Just go back to, just to close the loop on this, as to the statistical analysis, and that, again, looked at two main questions were addressed. What predicts palliative withdrawal of mechanical ventilation? And for those who had the mechanical ventilation withdrawn, what determines time of death?
Yes, that's correct. That was their main questions that they were attempting to answer.
And these, and again, we went over the findings that the range
was 0 minutes, or I think it's probably fair to say less than a minute,
Correct.
up to 165 hours,
True.
with the mean being, I guess there wasn't a mean, maybe that was, the last article was less than an hour.
Yeah, so here the median, which is the most common finding, was approximately 55 minutes, which would be 0.9 hours.
And so, fair to say, thank you. So fair to say that the findings in the Cook article with respect to the mean time of death for an individual after being palliatively extubated is similar in these articles. 0.9, 0.95.
Yes, correct. The findings of the two authors published in the papers were similar in terms of the common period of time that patients survive after terminal extubation.
And these are peer review articles because and that's part of the reason why you would rely on these articles, is it not?
Yes, both articles are peer reviewed.
Which means they're kind of double, triple checked.
Correct.
Moving now to the patients. And your findings with respect to each. I just want to set some general framework so the jury understands and you understand how I'm doing my questioning. Okay?
Yes.
Just showing you, for instance, James Timmons, the report, the supplemental report you authored. This one is 32M. Do you see that?
I do see that. Yes, ma'am.
It appears that what the process you've taken in these supplemental reports is you've cut and pasted a bit from the medical records in your initial pages.
Yes, that's correct.
Does that make, that's what it appears, is that right?
That's correct. Yes, ma'am.
And then after you're cutting and pasting the medical records, I presume that you think are relevant?
That's correct.
Because obviously these patient files are voluminous.
True.
And then, if we can, I don't want to give anyone a headache. Then, a moment. Towards the back of your report, for each patient, you then have a list, right, of all the things, things being findings and conclusions that you've made based on your review of the case. Do you see that?
I do see that.
And you type your own reports, you told this juror?
That's correct.
It's your own style, then, it appears, that words like terminal extubation or massively, or words like that, you capitalize.
That's correct.
So what I'm going to do is, in my questioning, I'm just going to go to the parts of your report where you have your findings.
Understood.
I think that'll be easiest for the jury, and that way we can be efficient with respect to copy. Let's start with Sandra Castle. Again, we don't know when the report was dated, but we know that this appears to be part of your report on Sandra Castle, correct?
Yes, that's correct.
I want to start with what we know now, or what I think you know now, is that Sandra Castle was extubated at 16:42 during the day shift. Correct?
That's correct.
And you are aware, are you not, that Dr. Husel works the night shift?
I am aware of that now.
So she's extubated when he's not at work.
That's correct.
I am assuming, doctor, that before you turned over your supplemental reports to the state of Ohio, you took the time and attention that a case like this warrants.
That's correct.
You reviewed those reports.
I did.
And I even heard you previously say that sometimes you have someone within your office double check just for typos and that kind of thing.
Correct.
Do you cut and paste in your report?
Sometimes, since there was a large number of reports, I did cut and paste.
So let's go to your second finding with respect to Ms. Castle. You wrote, to a reasonable degree of medical certainty, Dr. Husel made her DNRCC and withdrew life-sustaining measure. It had not yet been determined that she was irreversible and life-threatening state. So we know now that Dr. Husel had nothing to do with that.
That's a true statement. I was incorrect in that entry in my report.
Okay, so that's incorrect. And then,
Okay, let the record reflect that you crossed out certain parts of it.
yes,
so
well,
they will
this is not the state's exhibit.
I understand it's your exhibit. I'm not criticizing you, but I want them to know why it's there.
Gotcha. I will state that every time I do it. And then I want to go to 5 because it relates to 2, does it not? Where you conclude to make these decisions without giving the patient an adequate amount of time to declare her condition and salvageability is well below, all caps, the applicable standard of care. Do you see that?
I do see that.
So again, crossing it out, that doesn't apply because Sandra Castle's family made the decision.
Objection, Your Honor. There's nothing in the record that says that what counsel is saying at this time is true.
Okay. Let's go side.
No, we'll continue on. I'll pull the record. Don't want to lose the cadence.
As to
So,
going to make a record, or where are we?
no, it's,
I'm going to sustain the objection. Let's rephrase and
For sure.
ask it accordingly.
we'll come back to it. So then, and I just want to, well, I'll probably have it right here, actually. It works out well. Joint Exhibit 12, page 85 to 86. Does this appear to be part of Sandra Castle's medical record?
Yes, this is part of Sandra Castle's medical record.
And if you're aware, I assume you're aware of just general day shift versus night shift timeframes?
Correct. Similar names appeared throughout the record, so I did become familiar with which physicians worked the day shift versus which worked the night shift.
And this progress note is from Dr. Mahoney, is it not?
Yes, that's correct.
And flipping to page 2 here of the progress note, and let me go back because I want to make sure. This appears to be what time?
At 1:48 in the afternoon.
This day shift.
That is day shift, yes.
And I've highlighted for ease. It says Dr. Mahoney, and I believe actually the resident physician wrote the note and he adopted it. Does that sound right, Doctor?
Yes, that's true.
I had a long talk with her family. They have her living will. You mentioned that, right? That the living will can speak for a patient?
That's correct.
And tell me she would not want these aggressive interventions in this situation. Do you see then it goes on to say, we will plan for palliative withdrawal of support later on this afternoon when more family is present.
I do see that.
It goes on to say 43 minutes of critical care time that Dr. Mahoney spent.
That's correct.
This is in the ICU, is it not?
It is, yes.
That's because Dr. Mahoney's an ICU doctor.
Correct.
Goes on, the patient is critically ill with dysfunction of more than one or more organ systems.
That's correct.
Specifically, acute respiratory failure and requires mechanical ventilation. Do you see this right here that says without this, she would survive life-threatening decomposition?
Suffer.
I'm sorry, suffer.
I do see that, yes, ma'am.
Do you see that?
I do see that.
So, in response to the objection made, the records show that the decision to palliatively extubate Ms. Castle was made during the day shift.
Yes, it appears that the decision was made through the day shift. It doesn't specifically chronicle the discussion with the family, but it does appear to be made during the day shift.
Okay, and then, well, then I want to go to the progress note that I'm sure you saw with respect to Ms. Castle from Mark Dellinger. And again, that's another doctor, is it not?
It is, yes.
Patient on vent and not able to provide a ROS. What's that stand for?
Review of systems.
And so they spoke to the family because the patient couldn't speak to themselves. Is that what the medical record says?
Yes, it says that the son was at the bedside, which is how, and then that there was a conversation between the son and Dr. Dellinger.
So this is the second doctor that's talked to the family.
Correct.
And if you could tell me that time right there, that's a day shift time, is it not?
Yes, that's 2:28 in the afternoon.
And right here, Dr. Dellinger, so a second doctor, indicates, does he not, the family has elected to withdraw care, noting that she has a living will and confirms that she would not wish to be on support.
Yes, that was Dr. Dellinger's entry.
And then thirdly, if we could go to Joint Exhibit 12, page 811, this is the nursing note, which I'm sure that you reviewed in the course of your engagement in this case, by Nurse Adair. Do you see that?
I do see that, yes.
And it says, patient palliatively extubated at 1642, many family members at bedside.
That's a correct statement of what is written there.
And 1642 is a day shift, is it not?
Yes, 1642 is 4:42 in the afternoon.
So going back to your report, when you talked about things like, again, Sandra Castle, I'm now moving on to 12, that her acute medical conditions could have benefited from further treatment, you now must agree, doctor, that has to be taken out of your report.
No, I would respectfully disagree. My opinion of reviewing her records is that she would have still benefited from further treatment despite what was entered in the medical record.
So is it that Dr. Dellinger and Dr. Mahoney, you would just replace their names in the report as to the findings? So would your report read, prior to any decision by Dr. Dellinger with the family to institute DNR comfort care, status, and withdrawal support? Or let me go to page 1. Would your report have read, to make these decisions without giving the patient an adequate amount of time to declare her condition and salvageability is well below the applicable standard of care for Dr. Dellinger and Dr. Mahoney?
Well, again, this is not a malpractice case. I've learned that from the judge, that those terms shouldn't be used in a criminal case. But yes, in terms of these statements, they're not applicable to Dr. Husel since he wasn't involved in that phase of the care.
Okay. And then I'm assuming, if we go back to your report, again, Sandra Castle, just want to make sure in terms of the accuracy of your report, 16, it indicates that to have the discussion and change the status in the middle of the night. We now know from the records that 1642 she was extubated in the daytime.
That's correct. She was extubated in the afternoon.
So this, and I'm crossing it out, this is also not correct.
Correct. She was not extubated in the evening.
And I know, Doctor, we talked about cut and paste sometimes, but you would agree, would you not, that Sandra Castle was a woman?
I would agree. Sandra Castle was, in fact, a woman.
Just want to go one other thing with respect to 39. And again, the decision was made outside of Dr. Husel, but when you talked about that Ms. Castle's status was not yet terminal, do you see that 39 finding?
I do see that.
Showing you what's been marked as Joint Exhibit 12, page 486, appears to be Sandra Castle's direct charting flow sheet. Would you agree with me on that?
I do agree. That is the flow sheet.
And did Ms. Castle have a pacemaker?
I would have to recheck her record. I don't recall whether she did or did not.
Please check her record, yeah.
Yes, she did in fact have a pacemaker.
She did. And
Correct.
it was an internal pacemaker, was it not?
Yes, it was an implantable pacemaker that had previously been put into the patient.
And pacemaker, an internal pacemaker, beats for the heart? Is that a layperson way that we can say that?
The way I would phrase it to the lay public, it senses the heart to see if it's beating on its own, and then if it sees missed or absent beats, it will then pace the heart itself.
So it's there for emergencies. If your heart's not working, it kicks in.
Correct. It sends electrical signals to the heart to tell the heart to beat efficiently.
So just want to go to a direct charting flow sheet. You see the pulse oximetry here, right?
I do, yes, ma'am.
And you would agree with me that a 66 is not sustainable for life.
A 66 is defined as hypoxemia, which is very low and would not over time be susceptible or consistent with a prolonged life.
And you would agree with me that in terms of other measures, when there is an internal pacemaker, we wouldn't expect to see beats per minute. Is that right? Or, I'm sorry.
No, that's not
I guess blood pressure? Is that right?
That's not true either.
Okay. Tell me what we wouldn't expect to see as another measure other than the 66.
What you may not see is the patient's own heart spontaneously beating. What you would see are the electronic pacemaker spikes on the EKG, meaning that the pacemaker itself is sending the electrical messages.
And yes, that was couldn't get there, but I appreciate that. So we've got her at a 66 at 2,200. Is that right?
Yes, that's correct.
I want to just talk about the tolerance issue, because I know that's come up, whether someone is opioid naive or tolerant. Does this look like the medication administration record for Sandra Castle?
It does, yes.
Just want to go through her, I think the word was used course, but she was in the hospital from the 10th to the 13th. Is that right?
Yes, that's correct.
The 10th, she gets fentanyl. It appears 50 micrograms per hour.
That's right. She had an order placed for continuous infusion of fentanyl at that rate, 50 micrograms per hour.
And then about an hour and a half later, the infusion rate is increased, is it not?
Yes, it appears to have doubled to 100 micrograms per hour.
So the 50 goes to 100. And just so we're clear, the names on these orders, this is Dr. Hagris. Dr. Hagris, do you see that?
I do see that, yes.
Dr. Hagris, right?
That's correct.
And then again, so we've got 315, and then at 340, it's increased, is it not, another time to 150?
It is, yes, ma'am.
I remember on your direct that you talked about anoxic brain injury.
That's correct.
And did I hear your testimony right that if you have anoxic brain injury, you don't have pain?
Correct. If you have severe encephalopathy from anoxia, it would be impossible to consciously perceive pain.
And I ask that because if we go on to her MAR, we can just go, let's go here to her direct charting flow sheet. Does this appear to belong to Sandra Castle?
It does, yes, ma'am.
And would you agree with me that two different nurses, looks like Nurse Adair and Nurse Lachard, note pain?
Yes, I would agree that both of those nurses documented pain scores.
And we know that Sandra Castle had an anoxic brain injury.
That is correct.
And then with respect to Ms. Castle, you know from the review of the records, who intubated her? Do you know?
Let me just review my report. I believe she was intubated either by EMS during the 911, the paramedics, or immediately upon arrival in the emergency room.
And then she was transferred to the ICU, given the critical nature of her status, right?
That's a true statement.
Let's go to Ryan Hayes. Ryan Hayes, does that appear to be part of your report?
Correct.
And I know you were asked about this on direct examination, but it's your understanding as you sit here today that the decision to palliatively extubate Mr. Hayes was also made on the day shift.
That's correct.
And the reason, based on your review of the medical records, that it was done at night was to wait for a family member to arrive, correct?
That was my understanding.
So let's go to 5 in your report, where you say the fact that the patient had only recently been intubated prior to Dr. Husel rapidly proceeding with a 180-degree turn and approaching the family in regard to the DNR-CC status. That's a finding that you say is him falling below the standard of care, right? That's what your report says.
Again, I was instructed by
Okay,
Your
you
Honor
can
not to
answer
talk
that
about.
question, Doctor.
Okay. Yes, that's what the report says.
So now, as you sit here today under oath, you understand that actually Dr. Husel never approached the family, right?
It appears so. That's correct.
And so he never did a 180-degree turn, right?
That's correct.
So this, and if I can, for the record, so this that comes out of your report.
True.
And then it goes on, does it not, on 6, to talk about how though it may have been appropriate to discuss the status in the middle of the night, it was medically inappropriate. Do you see that?
I do see that.
Okay, so we know that this is incorrect because the discussion wasn't had in the middle of the night. Would you agree with me on that?
That's correct.
So then I want to go to your further statement about the discussion shouldn't have happened because it was medically inappropriate. So let's go to who had the discussion to talk about their. Do you see this progress note with Ryan Hayes?
That's correct. It lists Dr. Douglas Closure.
Joint Exhibit 2, page 22 to 27. You would agree that Dr. Closure, what department is he in at Mount Carmel West?
He was under the pulmonary critical care division.
In the ICU, right? But in the pulmonary
Correct.
section. This is his note right here, is it not?
It is.
Patient is critically ill, such that a high probability of imminent or life-threatening deterioration in patient's condition. Dr. Closure indicates that he spent 34 minutes of care. Do you see that?
I do see that.
Same progress note, I'm just flipping forward. Page 27, this is the same progress note, although Meredith Morse appears, it is the same progress note of Mr. Closure. It's a long note, if you recall. It says down here, does it not, prognosis is extremely grim. Family has decided on palliative withdrawal today. According to family, they clearly state the patient was very adamant about never being on life support and would not want to continue at this point. Do you see that note in the medical record?
Yes, that was entered by Dr. Morse.
Okay, so that's a second doctor.
That's a resident, I believe.
The patient is not brain dead, as he does breathe over the vent,
Correct.
right? It goes on to say, given the extent of his end organ damage and severe derangements in his kidney and liver function, patient is not a candidate for DCD and is not a loop patient. So that means, does it not, we can't save his organs, right?
Correct. DCD is basically